All right, well, welcome everybody. It's good to see so many people that have joined us. I appreciate it. And um, you know, from the very beginning, I want to say every PARB is different, and that's okay. You guys all do your reviews different ways, have different people, have different relationships with DHS, have different people that come to your meetings. The point is you're reviewing the cases and you're keeping an eye on the whole system, and that is the priority. And what we want to do in this training is kind of look at some tools that some people are using, concepts, strategies, because we want everybody to create the best recommendation as possible for the judge in child welfare. And I think it's worth mentioning that, your recommendation is not just for the judge. I mean, obviously it goes to the judge. That's your most important audience. But I've seen a lot of changes happen within child welfare whenever your recommendations impact how they do their work as well, or maybe others as well. So like I said, all boards are different and ways of looking at cases and writing recommendations, and that's okay. I don't want anyone running away from this meeting saying, well, Keith said or Kim said or Lee said that we're doing it all wrong. No, you're not doing it all wrong. There might be some ways that you can enhance doing it. And Tulsa and Oklahoma City, they do theirs a little bit different than the other areas as well. So some of the stuff I'm going to talk about, Oklahoma City and Tulsa folks aren't going to know what I'm talking about, and then vice versa. So we're all one happy family, right? All right. So regardless of those differences, improving PARB recommendations can help build rapport with the court, DHS, and others for the good of the families. At the end of the day, I think the recommendations that we submit to the judge and to the other players is kind of our homework, is our calling card. And the better job we do at that, the the better our product looks, and the more the judges really can respect what we do and support what we do. We believe that any review helps case by keeping an eye on what is going on and reporting to the judge in child welfare. So you all know this. If someone is working, even yourself, you're working, by yourself, no one's checking on you, no one's asking how you're doing. You may not work as hard. You may not stay on top of things. You may let things slide. So the whole concept of, a watched system performs better than an unwatched system. I think you all can certainly believe that. And we also believe there's always room for improvement. No matter how good the recommendations are, or good your PARB is, we feel like, there is always something that you can do to get better. And we want to share, some of these different ways for your consideration. So one thing that I've been kind of concerned about when I go out in the field, or kind of been looking at, is whenever, most of the rural counties or non-urban counties look at every single deprived case in that county, and that's what you're supposed to. That's what our statute says. The only reason we don't do it in Oklahoma, Tulsa, Norman, and Canadian County is just we don't have enough volunteers to review every single case. We just can't get it done. But it's not from lack of desire or lack of the statute saying we're supposed to. So most rural counties look at every single case. Therefore, a lot of times they're trying to get through them real quickly. I saw that in Bryan County. Bryan County Board's not active at the moment, but I remember seeing them go through 40 cases in one day. You can't do a good review if you go through 40 cases. You just can't. It's not physically possible to understand that. So only review the cases you really need to. And to do that, you're going to have to track cases, unfortunately. Most boards follow the deprived docket. So the judge is going to look at these 6 cases on Wednesday. PARB board meets on Monday. They review those 6 cases. Or they're going to meet on Wednesday plus the following Wednesday. So you look at those, 10 cases, whatever. That's good. That's a good place to start. However, a lot of judges look at cases every 90 days. Our statutes say we only have to look at cases every 6 months, not every 3 months. So there might be some cases where you want to, not look at those as often. And also, a lot of folks will follow kind of the DHS list. So they'll basically look at every kid every month that's in custody. And in some counties that kind of works, but really you don't need to. You really just need to, the ones that are coming up for review. Obviously, if there's one you want to keep an eye on, you can do that. You know, say, hey, I want to see this one next month because I want to see what happened. Plus, you can thin out a case, you know, especially if it's within that 6-month window. Oh, they're about to be adopted, or you really, you know, you really gave a good recommendation last month on that case. There's really no point in doing it again. You can choose which cases you review for the most part. You have to look at every case every 6 months, but if you're within that window, you can certainly thin them out. And I would encourage you to do that. And if you need help kind of figuring out how to track your cases, please, please let me know and I'll help you do that. Plus, one thing we don't talk about much that I know not everybody picks up on is the ICPC cases. That means the ones where they have a court case in another state, but they live in the county that you're reviewing cases in. Those aren't going to show up from your docket list. Those are only going to show up by asking DHS about them. So if you're only following the docket list, you're missing the ICPC cases. If you're only following DHS's list, you're missing the ones where it's ICPC the other direction. See what I mean? So there is a little bit of, it's not wrong to follow the deprived docket, but there's some tweaking that you can do to do better. Hear from as many people as possible. And I think Lee and I were maybe in an email debate about that a little bit yesterday. If you only hear from one party, if you only interview one witness, you're going to totally agree with what they say, right? Because you got all your information from one source. Everybody has or should have child welfare at their meetings, participating or getting information from child welfare. And we've gotten some of those negative feedback in the past where we only agree with child welfare. Well, if they're the only ones we ever hear from, then we can't help but agree with them. And there's nothing wrong with agreeing them, but I'm just saying, if you only hear that, that's the truth that you're basing everything off of. I think, you know, what most boards also do besides child welfare is looking at the case file. That's kind of the most second comment. And I really think you need to do both. And if you're not doing both, let's talk about how to do that. Logistically, sometimes that can be a little challenging. I know not every board meets in a courthouse. And case files don't leave the courthouse. So if you're not meeting a courthouse, you're not necessarily looking at the case file. But there's ways to get around that, like in Pontotoc County. Carol can tell you that they go in and they review the case before the meeting and take notes and then meet later. So looking at the case file certainly helps. That way you know what the DA is saying. You know, maybe child welfare's ISP is different than what the DA was saying are some of the issues. If there's CASA, inviting CASA to your meeting can really help. Sometimes if none of your members ever attend court to actually hear what's happening in the courtroom and the hearings, I would suggest you maybe assign one or see if someone's willing to do that, so you hear what the different parties have to say in court, especially for the cases that have been in for a long time. And of course, you know, my dream too is to get, you know, foster parent input. And then also, you know, a lot of times, especially in smaller communities, folks kind of know about these families. You know, maybe someone goes to your church, and I mean, I know there's some closeness with that, but you certainly can share information if you know what's going on with that family a little bit. Also, you know, ask the judge how you're doing. We serve as kind of an arm of the court, as an arm of the court, and certain judges like things certain ways. You all know that. And if you don't have, you know, judges don't attend the meetings, though I've seen a couple come before to make sure everybody's got coffee and donuts, come after to answer any questions. But for the most part, they don't attend that meeting, and they shouldn't attend that meeting. But you can ask them, hey, the recommendations we wrote you last month, are we on target? Are we identifying the things that you want identified? You know, is it helpful? And I've already kind of gone over, slow down and look at cases only every 6 months. So again, if you're having trouble figuring that out logistically, let me know, because it is a little bit of a challenge. That means you have to track cases. But with this new data system, it should be a lot easier. Remember too that PARB's role is to be an independent observer, not to criticize, but to provide thoughtful, unbiased, and constructive input to the judge, DA, and DHS, so the children spend the least amount of time without safety and permanency. We want to write recommendations that are helpful, meaningful, and help move the ball forward for sure. I've seen this in communities where, as you all know, a lot of child welfare staff have a kind of a frequent turnaround. There's a lot of turnover in child welfare, and a lot of our PARB volunteers have been in the community for a very long time. You know, retired school teachers, service providers. Sometimes they're active service providers, like a multidisciplinary team, or crisis intervention center, or area prevention resource center, or mental health center. So a lot of our volunteers know what is in the community as far as available services better than child welfare workers do. Sometimes better than the judges. You know, a lot of time the judges, this is not necessarily a field that, you know, they had planned on being in or been worked at for 20 years. So knowing your community resources can be a really big help. And what I mean by community resources is, you know, services available to children within child welfare custody. And know what typical services are about. I'm real excited about the training coming up next Tuesday from DHS to kind of talk a little bit about what are some of their standard services. What are, you know, if this happens, they go to this. If this happens, it goes to that. I think understanding what, say, CHUBS is, and what the mental health center does, what OCSA is, which is the independent living services, knowing what kind of a lot of this population, the type of services they get, what they do, and that way you can suggest it. And I think it's great too if you all would just schedule lunches or schedule visits, or just call your local director of the mental health center or youth service agency or area prevention, keep saying area prevention resource center, I'm talking old school. But you know, just any different service providers in the area, community action agency, you know, just look up social services in your neighborhood and ask your board, do you all know what this agency does? It's like, no. Well, why don't we invite them to give a 10-minute spiel at our next meeting before we get started? And then that helps you know more information about what's going on. Also knowing some of the more formal services like developmental disability services or an individual education plan, IEP in school, some of the more government, you know, qualified services like maybe food stamps, knowing what those requirements are, so you'll know, hey, I think that kid could get some DDS services, you know, and make a list of services. And our user, if you don't have the PARB training manual and you'd like one, let me know. I keep them in my magic briefcase when I'm out traveling in case anyone wants one. But it can be a reference document for you know, for lots of things, our statutes for one, but also it talks about kind of what are some of the typical services. And of course, tenant court, we've already talked about that. Someone on the board say, you know, and I know in some areas we've got some volunteers that actually that's part of their job description for what they do, or they're a CASA, so they're already in, you know, they're already in court. But not every board is as privileged to have that opportunity. So you have to kind of see and visit with the judge. Our statute says we can attend court anytime, but it would be rude to just impose and show up. It'd be better to check with the bailiff, check with your judge and say, hey, I'd like, you know, one of our PARB members would like to start attending, and then talk to them about it. So how reviews are conducted. Individual assignments or group only. And again, in Tulsa and Oklahoma County, you all get your cases ahead of time, which is great. You get your files, information shared ahead of time, and you've got some time at home to sit and digest that information. Everywhere else, it doesn't work that way because you don't have a staff person. It's only volunteers. no one in the local community has access to OSIS, the electronic system. And not every even rural county even has cases on OSIS. So basically, they can't look at you everywhere else. You can't look at the case information, the file information until you get there. So what happens most of the time, unless you get a DHS report, so what happens most of the time is you find out, okay, we're gonna look at these 10 cases or 12 cases. We've got everybody, you go pick up those files, put them in the middle of the table, and at the beginning, you hand out the case files and say, I'll take these. Oh, that's the Smith family. I saw them last time. I'll look at that one again. That's kind of how it's done, which is great. You might, and sometimes it's kind of just a group thing where it's just kind of everybody kind of goes over them, and then maybe one person, like the chair, writes the recommendation. None of those are wrong ways to do it. I think if there's, if it's everybody's job, it's nobody's job. Everybody's heard that before. I think if you have individual assignments, then you're maybe apt to listen a little bit closer. If you have different people that are writing the recommendations and not just the chair, you're going to have kind of a different voice. And we'll go over kind of our checklist later, but have a checklist available to know what to look for. Sometimes, and we were talking about that before the meeting, you don't always know kind of what to look for. Using those checklists, which are the tools we're going to share with you, kind of helps trigger that. And then of course, read your recommendation out loud to the rest of the board for ideas to make sure that it sounds right. Most boards do that, but not always. I think that's real helpful when you do it that way. So who asked the questions of DHS? I've been at some meetings where it seemed like the chair felt like it was their responsibility to interrogate DHS and no one else's. I don't agree with that. And if you're uncomfortable, if you're new to the board and you're real comfortable asking questions, fine, don't ask questions. But I'm saying, maybe move towards that. If you're a member and really not sure what to ask, look at that checklist and say, oh, the checklist says you're supposed to have, ISP approved within 2 months. Say, did the ISP get approved in 2 months? And they'll be able to tell you or not. So who asked the questions? Just the chair, all of you, the person assigned. Again, I like it when people are assigned because then they take that ownership. So not that, and I've seen this a lot in Canadian County where you've had maybe one member that doesn't have a whole lot of child welfare experience assigned to that case. So they're trying to ask questions the best they can, but then you've got someone who is retired after an entire career within child welfare really asking the questions because they know what to ask. That's okay, but you've still got this assigned person going, oh, that's a good question. Oh, that's a good, and writing frantic notes trying to, track that. So, I'd really like you to kind of consider that, who asked the questions of child welfare and how, what questions you ask and how you kind of engage in that. So checklist and sample recommendations. So use as a reference, not complete all the boxes. Okay, I want to make sure that's clear. So let me go to this one. So this is something, and I know it's kind of small print. I can, here, I'll zoom in a little bit. This has some of the timeline things that you can kind of put the date over here. Like, was it ICWA? Who's the tribe? Was the ISP written within 60 days of removal? Dispositional hearing. These are just things to trigger your mind. I wouldn't be flipping through and asking child welfare, every single one of these things. Was the, adjudication as to father within 30 to 90 days. Not that that's not important information. And Kim will get after me if I don't say it is, but I don't want you to sit there and go, check here, check here, check here. I just want these things to trigger you a little bit. So this, whoops. There we go. So this is what Leah embodied, and Leah, I hope you'll talk to this a little bit in Creek County. Her board and her came up with this a while back, and it's kind of steps kind of something you would give a new member or someone who's fairly new that can kind of say, okay, I do this, and then I do this, and I do this. These are steps for her board. They're not universal, but I'm showing this to you for a couple reasons. One is I want you all to think about how you process information and what are things that you maybe historically, every single one of you guys has a culture in how you do things, and you typically do this and you do this. Maybe start writing that down so the new member's not completely lost, or try to figure out, okay, well, why do we do it that way? Maybe we should do it a different way. In Creek County, they have a form, which is, oh, not letting me click. Okay. I'm looking for the, I guess I don't have that inside cover that you've got.
Hey, what?
Do you remember Natalie Michaels from this whole?
Oh,
Did she apply? Good.
can you, there you go, thank you. But anyway, so like here, current review process that Lee has, keep in mind the child's age and how long they've been in out of home placement. So a younger child that's been out of home for a long time, I mean, is more significant as far as development and school and everything else than a 17-year-old. Not that it's not, you know. Are there any previous child welfare issues, relinquishment, termination, or reunification? That tells you a lot. So do we need a, you know, one thing that they developed there that I thought was really interesting is, do they need a document signed by the judge to close the case? They realized that they would look through the case file. A lot of times the case was closed, but the judge hasn't signed it. So it kind of almost turned into a in-house quality control for the judge, and the judge really appreciates that. And that happens in other counties too. If natural parent is absent, is publication being pursued, paternity testing. You know, again, these are things to kind of think about. And I'm not going to go through every single one, but just wanted you to have that as a reference, and I'll send this out to everybody who participated, and encourage you to maybe develop some of your own questions as well.
Yeah, Keith, I developed this primarily to help give a leg up to new members so it would give them a guide for how to approach digesting the information in a case and what might be important and what might be less important. Instead of just focusing on dates, some of those dates are important, but also how are the kids doing? Are we just getting information on the parents' ISP, but nothing on the kids, stuff like that. And I found that it helped. I mean, this is specific to our board, what I thought our board needed, but it also helped some people whose recommendations I thought could be improved, to help give them some triggers for, oh, okay, I need to think about this too, and I haven't done that in the past. Is more kind of a guide to help people think about a case.
Yeah, it's great. It's great. And I definitely would encourage everybody to think through all these tools and think, what maybe would help move your board to the next level on your recommendations. Lee, any other thoughts?
No, I just would encourage people. I mean, different boards, like you say, they operate differently. So a different kind of approach may help them, but almost any board with new members, if you can think of ways to give them a leg up, I think it brings them up to speed faster and they feel more comfortable faster. You're less likely to lose them because they feel inadequate.
Yeah, exactly. Exactly. And that happens. And I think you all need to acknowledge that. We literally have people. I mean, Shirley Roberts was the DHS director in Osage County for like a long time, and now she's a volunteer in PARB. You've got Jerry Poplin, who was retired DHS at Canadian County, along with some state office folks from child welfare serving on that board. So we end up with people that know child welfare in and out, and the statutes and the history and stuff like that. And you got people, you know, that just, you know, hey, I just care about kids in deprived court. I don't have any, and bringing those together, I think is important, because I think if you only had the experts, then you got the choir talking to the choir all the time. You need folks that don't have a whole lot of experience. But if you just had them, then you're maybe not going to answer, you know all the ins and outs and specific things to, so it takes both, but the folks that don't have all that experience are going to sometimes feel lost. And I think everything you can to do to help encourage them. I really think it's important we have both voices. So it's definitely helpful. And tools like this, I think, certainly help. This is something Christina Watley put together for Oklahoma County for her transition board that I think is really nice. Again, I'll send this out because I think this is good information for transition age cases. But you know, it's basically, I asked her, you know, what are some of the things that like come up every time with your transition cases? Because you do kind of get in a way, you're like, you ask about this every time, you ask about that every time. So start writing those down, and then that way you can hand that to a new person. Or you can say, why do we ask that question every time? We need to ask this question's better. So she's got, you know, the petition, what brought the youth into custody? They want to know that. I pretty much look at that every time. What's the initial, was in the initial petition? Are they receiving Oklahoma Successful Adulthood Services? You know, if not, why? Is there a plan for my future in the 7 key elements? So they have their essential documents like birth certificate, social security card. Are they interested in the, you know, college or trade school? You know, just stuff like that. And then I've got links to those things down here that'll be in the report that you get. But again, this is one fairly specific thing where people have written down kind of the questions of the things they're concerned about, and anybody can do that. Or you can steal the ones that already exist or make your own, either way. All right. So I want to share you now again, you know, everybody's on an evolution. No matter where your particular PARB is or how you do things, you're doing a whole lot better than the 20 counties in Oklahoma that don't have PARB. So if some of your recommendations that I say, you know, these are not your best recommendations and you do this, that's okay. Just move towards seeing if you can make them better. So, you know, recommendations I've seen that are not necessarily the ideal. Board supports adoption. Well, why? That's just not enough information. Terminate parental rights. Of course, we get teased about that all over the state for that being a recommendation. I need to talk about, you know, why you're saying terminate parental rights. Are there other things? Is there something you can validate, something you have concerns about? Concur with DHS, continue with plan. I see that a lot too. These others are kind of funny, but I've seen them as well. Why is this mom allowed to have children? And please do something about this father. So, and now we got the data system. I can see recommendations all over the place, not just when I'm out in the field. So here's a couple that I've found in the system, in the data system, that really struck me as good. And it didn't take me long to find really good ones. You guys really do a good job of writing recommendations. The board supports the plan. Okay, great. That's a little generic, but I mean, but continue working on OCSA and other resources to help that somebody's name successfully transition to adulthood. So that's validating what's already happening. There is nothing wrong with agreeing with child welfare. There's nothing wrong with telling child welfare they're doing a good job. Matter of fact, I wish you'd do more of that. Specifically, like, I really appreciate you going above and beyond to make sure that bio mom had visitation with her baby, you know, something like that. I'm going to look into, and then now here's something, you know, a suggestion about something that can be done. Look into what youth and family services may be able to offer for independent living as well. So, okay, we're acknowledging where you're at. You're working with OCSA, keep it up. Now, look at what youth and family services might be able to do as well. And that shows that that board knows what's in that community. You know, may also pursue involving data and therapy if that would help the kid open up. I mean, that to me is very specific recommendation and just great. Here's another good one. The PARB is pleased with quick development of the comprehensive ISP. Again, validating. Then, here's the carrot, here's the stick. We're disappointed that Developmental Disability Services case manager did not identify the abuse earlier or work to address the malnourishment of the children or identify the domestic violence perpetrated by the mother. I mean, that is very positively stated. We are disappointed. Not, DHS didn't even identify the abuse that happened earlier. There was malnourishment going on. No one caught it. There's domestic violence. No one caught it earlier. I mean, those are some pretty serious things to highlight, but it's framed in a positive way. I hope that DHS and DDS will continue to work together to address the needs in the home. So, that's just, again, good recommendation in my eyes. So with that, I think I'm going to stop my part. Kim, is it okay? Oh, Johnette, you had a question?
Yeah. I noticed on this form and on our CASA forms, and I didn't know that PARB had this on it, that a number of months out of home, and DHS never considers that first month in their counting. So we, PARB and CASA, would be the only ones to let the judge know how many actual months it's been, because DHS goes by the first full month, which can be off a whole month then, and usually is.
Okay, good to know. Good to know. Well, and that's something with the new data system that it's hard to find the first time, as opposed to before, the forms would say number of months out of home. So you put 10 months or 12 months or whatever. Now the new data system wants you to put the date of, I guess, adjudication, right? The date of removal. Kim, which one do you guys use?
That's a tricky question.
Okay.
I always feel like my answers are a little tricky. So there's two metrics. There is the actual months out of home, which would start running from the removal date.
Right.
But statutorily, that is not how you calculate time if you are looking for those metrics like 15 out of 22 months or 6 out of 12 for children under 4. The law calculates the time out of home differently. And that's a formula that is essentially, either 60 days from removal or the adjudication date, whichever is earlier. So it's a simple formula. It's in our training presentation, kind of we do with all new members. If you want to reference it, it's also in the statutes. But I always tell my volunteers, because the time is really most important if you are going to be looking at, which I don't, again, push, but if you are going to be contemplating whether or not termination in your case is a recommendation you want to make, you don't want to look just from the date of removal, because your time will be off, sometimes up to 60 days. And so,
Kim, I might add, this is Millie Carpenter. And for those of you, when you're looking at the court file and you see the individualized service plan, what Kim said as far as the calculation for the date of removal, it gives that same verbiage for that reason. And as I believe Johnette said, it is important because the judge may not see this, in terms of out of months and out of home care any other way except the way we present. So thank you for clarifying.
Yeah, it's funny. I thought I was asking a simple question, but I guess I wasn't. Well, no, I'd rather the right answer, whether it's simple or not. Things are not always as simple as we want them to be. So with but now what I was going to say, on the database, you actually enter the date of removal, and then it will, next time you look at that case, it'll tell you exactly And when you
Right.
print, it'll tell you exactly how many months out of home. So even though that initial date's hard to find, once you find it once, you're done with it. It'll always be there. And that helps you make decisions as a PARB member on what recommendation to write. So Kim, Millie, whoever, Jonette, where would you try to find that date? Would that be, if
It's,
you're gonna enter that date?
it's going to be
in
on the
case
order.
file. Yeah.
Going to be on the order removing. Yeah, or you can look at the emergency custody hearing order, which is the court uniform order. That's, most counties should be using it because it is the uniform order. That emergency custody hearing order, that hearing may happen 48 hours after removal, but that order has a place in it where the court should put the removal date. So you should be able to access that order at the very least.
Well, and I encourage, well, I've got everybody's attention. I encourage you to enter that date, even though I don't think it's required. I don't think it's got one of those little red flags on it. And I encourage you to put the KK number in too, just while I got everything. All right, Kim, your turn. Do you,
Hey Keith, can I ask a question real quick? This is
Yeah.
Millie. I'm glad that Millie's on, and Millie, I want to, in the realm of complimenting DHS, I have never had a problem reaching a worker or a supervisor. They're so helpful, but I think I've been a little at fault because when I do my PARB review, I think of DHS's role as being the person that gives me information. I'm kind of curious what the feedback is as far as, do the DHS workers and supervisors see the reports? Do they take the recommendations into consideration? Because it's not just for the judge.
I think you're correct, and I'm not really part of child welfare anymore, but I consider myself always a part of it. So I think what I have experienced in my brief time on the Cleveland County PARB is that the feedback I've received is, yes, child welfare staff are reviewing the recommendations, and they also, I have expressed appreciation when we make, when we have conversations with child welfare staff, that either we provide insight on a resource or some sort of supports for a parent or parents. And one thing we discussed yesterday was a worker was not aware that when a child is in DHS custody, she was looking at, well, I don't have consent to get the therapist's information for the child. And, there is a way to do that. And I think in her mind, and even in the supervisor's mind, they felt like that was not a possibility. So I think it's a learning opportunity for all of us, as whether you're child welfare or you're a PARB member or your PARB and CASA, because as Keith said and others have said, it really brings together, I think the collective thought on looking at, permanency for the child in the safest manner possible. And every county is different, and there's just no way around that. But I think to answer your question directly, yes, they look at the recommendations.
This is Naomi, Wagner County PARB, and I worked for DHS for 15 years, and 7.5 years were in permanency planning, where that PARB recommendation comes back to the worker. And I can tell you that that PARB review is not considered. We get it, we file it, and we put it away. And the reason is some of the times that is happening is because we're drawing our information from the court file, and the court file can sometimes not be as accurate, or we don't get a PARB, a current one, from the worker's office. So mine is a little bit different than Millie's experience. So I just wanted to let everybody know that's not this, it's might be 50-50.
Yeah, good point. And I'm only speaking again from my experience, brief as it has been with Cleveland County PARB. So thank you for that.
well, and I would encourage you, and Naomi, I've been out to your board, as you know, and I need to visit with more about getting DHS involved. But anytime I've discovered that a board doesn't have the involvement with child welfare that it wants to, that it's a fairly easy fix. The reason for that is manyfold. Sometimes talking to the wrong person, the supervisor doesn't understand PARB's role. There's a million different reasons, and and they're all innocent reasons that can easily be resolved. So if anyone's struggling with child welfare, please reach out to me, and Naomi, I'll follow up with you, and we'll see if we can get some of that resolved.
I think one of our biggest issues right now with child welfare is that we don't have many workers who are trained not only to do their job, but to understand the importance of PARB. I mean, that is kind of like today it's not a grandfathered in episode. It used to be a grandfathered in episode. I've known about PARB ever since I started working for DHS, but I don't think it's put to the forefront anymore, unless since COVID, because the workers are not in the office.
Right. Yeah, that's been a challenge as well. Well, I want to make sure Kim has plenty of time, so let's go ahead and transition to her. I guess if you're host, Kim, you could probably share your own screen. You want to do that, or you want me to keep going, or? I can keep going.
Yeah, how about you just keep going? I'll just hit next when I'm ready. So this slide I'm going to kind of breeze through because Keith, I think, touched on quite a few of these issues in our checklist that are included in this presentation, also give you some hints. I come from, my experience is 99% on the legal side of things. So I tend to approach my training and my work with my Tulsa County Board from a little bit more of a heavy legal perspective, but I try to highlight the things that I think are super important for volunteers to know before they make a recommendation. And we're going to talk about each of these points a little bit more in detail, but I summarized them right there. What are the conditions that the parent needs to correct? I think you have to understand what those are to be able to evaluate progress in a case. And I cannot say it enough. I'm going to say it here. I'm going to say it again, that statutorily, progress is not judged by a parent's progress on the treatment plan. I use this example when I train everybody. Has anybody in this presentation ever smoked? I'm going to assume that some of you have. Okay. You would agree with me, hopefully, we don't have time to take a poll, but that you can quit smoking without help. It's hard. It's difficult. It would be a challenge. Your probability of relapsing is probably high, but you can do it. People do it all the time. You would also agree that if you got treatment, you may not be successful. You can get treatment to quit smoking and continue to smoke. That's why the distinction in the law about what is your guideline for successful completion or correction of the conditions is not checking boxes off the ISP. It's whether or not there have been behavioral changes. And the reason why it's hard to get good recommendations by just doing a paper review is because you don't get the opportunity to really dig in deep about what those behavioral changes are. What is the worker seeing from the parent? What are the foster parents seeing from the parent? What are the children, if they're older, seeing from the parent? Because mom and dad may not go to a particular class that's on their ISP, but they still may fix the problem. And so your evaluation, I think, if you can, and you have the tools and the means, or at least the very goal, should be to really dig deep beyond just the paper. Visitation, and they're now called family time plans. I want to make that very clear. And people say, well, what's the difference? There's a big difference. DHS rolled out a couple years ago a new model, if you will, and how they approached visitation. And they now call it a family time plan. And there are some very distinct cultural approaches between the two. I did a training on the whim a couple weeks ago on these, and I think some of the individuals that participated in the training were a little bit surprised to find out what DHS's policy about visitation and family time plans actually is. And I've mentioned to Keith, I think it would be good to do for our PARB boards, and definitely on a large scale, because it might shock you to hear that DHS is their instructions from top, from head down, is that they should start with the least restrictive visitation plan that provides safety for the children. Whereas before, the mentality was you start very strictly, supervised once a week. Is kind of the average. It's actually the opposite. You start unsupervised and you work your way down to these specific categories. And you have to justify why you're restricting visits instead of justify why you're unrestricting them. And I think it's a totally different mentality. I think it started a couple of years ago, but to be honest, I think it's now made its way. Things like that tend to make their way through the system slower. So if you guys are ever interested in that training or information, I'm happy to send it to you because I think it's something on the level. But know that, and always know in the back of your mind what the court determined the permanency plan was, because that determines kind of what direction the case should be going, what effort should be being made between the last court hearing and the one in which you're reviewing it. If you're struggling to get started, Keith provided these checklists, but we also have within our PARB manual, there is a series of questions under several different topics that might give you a jump start. So yes, and so you can refer back to that if you need be, but there's lots of great resources. Okay, Keith, next one. So reviewing the case file, this sounds pretty simple. I want to be sure to point out that statutorily, and if you ever need the site, it's actually on PARB's website. When you go to statutes, it's included in there. If you cannot find these documents in the court file, or you want them and they're not there, you are entitled to request them and review them. It is not, an additional court order is not required. So if there's ever a document that you are like, wow, I would really like to see this, all you have to do is ask the worker for it, okay? You may get the worker saying, no, I'm not entitled to give that to you. I bet particularly newer workers will, but talk to the supervisor or get with Keith if you're having that difficulty so he can help you intervene. But the things that I think are just, common sense kind of, I think most of you do this, is the petition. You've got to know what brought the kiddos in. DHS reports that give you a history. Any prior PARB recommendations, CASA reports, the visitation orders in the family time plan, I think is critical. All the court orders so that you can kind of follow the history of the case, and any treatment plans. Pretty basic, so we can move on. Okay, this is where I think it's important for you as a PARB member to know, if you are set to review a case, what type of hearing is that case set for? Okay, so there are different types of hearing within the child welfare system. There's the adjudication hearing, the dispositional hearing, the permanency hearing, and the review hearing. Okay, it's important to know what type of hearing the case is set for, because that determines what the judge will be reviewing in that hearing. And if any of you are familiar with the legal system, and I'm sure most of you are now, then you probably understand the concept that when you go into a court for a hearing, you expect the judge to stay within the confines of those hearings. If a judge goes outside of the confines of those hearings, you start getting notice issues. You start getting participation issues. You start getting judges making decisions without maybe having all the information. So knowing what type of hearing your case is set for and what the judge will be reviewing within that type of hearing will help you tailor your recommendations to be helpful to the judge and the parties. Does that make sense? Okay, yeah, if you're making recommendations on issues that is not set before the judge is going to be less likely to address your recommendations. Okay. For example, if the court hearing is set for a permanency hearing and your review focuses on the paternity issues, the judge is not necessarily going to be able to incorporate your recommendations into the court hearing because the appropriate parties aren't there. They haven't been given notice. That's what we're going to talk about. So you need to make your recommendations relevant to what the court's actually going to be reviewing. Okay, next slide. And I kind of give you some guidelines on that. So these are the types of hearings that you generally should not review. If you see this on your docket, and if you'll see over here, I know you can't see my mouse, but I tried to take, it's a little messy. We tried to block out for confidential reasons, snippets of the docket, of a docket that shows you, if you have the opportunity in your county to look at a docket, your docket should tell you what type of hearing you're set for. I mean, it should. Not all of them do, I recognize that, but it should. And if it does, these things might help you identify good cases to review. For example, these are hearings on the left side that I would not review. If it's set for a service issue, don't review it, because the judge isn't going to be making any findings relative to the children and anything substantial. The court's just going to be evaluating whether or not all the parties have been properly served. Adjudication, generally at that phase, it's a little too early for PARB to be involved. We're not supposed to review cases until we hit a certain statutory point. If it's set for the results of genetic test, again, I wouldn't review it because you're not going to be able to make recommendations that the court's going to be able to consider in that hearing. If it's set for a trial, motion hearings, absolutely, depending on what the motion hearing is. And I put an example down here. So this case was coming up for review on the docket, and it was only set specifically for the motion for sibling separation. Is it okay for PARB to review that case as it relates to sibling separation? Sure, absolutely. Yeah. Are you going to, in that report, detail what you think about the parent's progress? No. Why? Because that's not what the court's going to be reviewing at that particular case. The court is only going to be reviewing the issue of sibling separation. So if you're going to review it for that particular hearing, be sure you're reviewing it for the issues the court's going to address. I hope that makes sense. Okay. Keith, we can move on. Okay, so adjudication hearing, you all know what happens there. I say that generally this is not a great place to review cases unless the child has been held in an out-of-home placement for 6 months. It happens. I know it happens, particularly in some rural counties. So you definitely need to keep your eye on that because there's a lot of legal implications if that's happening. But mostly, in probably the majority of counties, the adjudication is going to occur prior to that 6-month mark. So next slide, please. Okay, the dispositional hearing is actually, I think, one of the most important hearings for PARB to aim to review cases. I think a lot of PARB boards tend to focus on the permanency hearings, and that's fine. That's okay. But if you can start getting your cases reviewed a little bit earlier, such as disposition, you're going to find that your recommendations could be potentially much more impactful. So I want to be very clear that a lot of people equivalate the dispositional hearing with the entry of a treatment plan. Okay, that is only one thing that happens at the dispositional hearing. That's only one. Okay, there are multiple things by statute that the court reviews at a dispositional hearing. The first is who gets custody of the children. If you're reading a case and you're like, okay, I'm really struggling to see why this kiddo's in foster care. Like, yes, there were concerns, but mom and dad have jumped right on it. The children have been in foster care 4 months. Doesn't seem to be there's any safety concerns. Why are these kids still in foster care? That's a perfect time to evaluate that and to make a recommendation to the court that the court look at returning the children home or look at returning the children to the non-custodial parent. There's multiple options. This is where the treatment plan for the parents is entered. Again, treatment plans, the reason why I stated in that first slide that you understand what the court told parents you need to fix is because the treatment plan should line up with that, right? If the court told the parents that you need to fix your issues of substance abuse and domestic violence, as a PARB member, you're going to want to make sure the treatment plan, at the very least, addresses those two issues. Okay. A treatment plan should be entered for every child. It looks just like the treatment plan for the parent. And I cannot emphasize enough, this is one area where I feel like PARB can be a major game changer. And here's why. I give this example in my training. If you had a kiddo that's removed from his home due to domestic violence, and that kiddo is at school, mom and dad do their treatment. They go to all their classes, right? And the parties feel comfortable that they've corrected that condition. And the 7-year-old is at school and constantly getting in trouble for slapping, hitting, manipulating, threatening, all trauma-related behaviors that child probably experienced in the home. Okay. His treatment plan said he's going to go to school, DHS is going to get him medical treatment, and that's it. Okay. So trial reunification comes along, they put the kiddo back in the home. Mom and dad get a phone call from the school that the child's hit Sally and tried to strangle Sally. So they go up, they pick up the kid, they bring the kid home, they spank him and put him in timeout. Because he gets spanked, DHS comes back into the picture. Have we really fixed the problem? No, and here's why, because we only fixed one part of it, right? There's a lot more to family dynamics than just the parents. We've got to make sure that when we are looking at a case and we're identifying, hey, these are the problems that the parents need to correct, there's always going to be a corresponding trauma to that child. Almost always, okay, that we need to make sure we're addressing. If we aren't addressing that unit, then we're likely setting that family up for failure. So maybe some therapy for the child specifically related to trauma as a result of exposure to domestic violence. Bringing parents into that therapy so that parents understand this is what this looks like. This is why he's behaving like this. This is how you can address this if you have these issues at home or at school. That education piece that we often overlook is crucial to making sure we're doing more than just treating one symptom. We're not treating the problem. I talked about it. I'll say it again. Be looking at the behavioral changes, not just checking off boxes. If siblings are separated, there should be a visitation plan, not only between the parents and the children, but between the siblings. That should be part of that family time plan. If you're not seeing those, address that. The court determines the permanency plan at the dispositional hearing. That's really the first time the judge is looking at the case to say, hey, I think this is a return home, or I think this is a concurrent plan for return home and adoption. It's a great opportunity to weigh in on what direction you think the case should move going forward. It's also the first time, remember, reasonable efforts start at the moment an investigative referral is made, okay? It's something that is an ongoing, continual requirement. You should always be evaluating your cases, and disposition is a great place to do that. Of, hey, is the state making reasonable efforts? Okay, next slide. The permanency hearing, which I think most of you guys are probably familiar with. The permanency hearing by statute is where the judge determines what's the permanency plan going to be. Is it going to be adoption? Is it going to be guardianship? Is it going to be return home? Or is it going to be planned alternative placement? Those are the only 4 federally recognized by AFSA permanency plans. Now, I will tell you, you can have a concurrent plan, meaning you can have 2 plans at once. But in order to do that, the primary plan must be return home. You can have return home with adoption. You can have return home with guardianship. You cannot have adoption with guardianship. Okay. I know it makes you think, why not? It's just a federal thing. And so when you're at a permanency hearing, the judge is really looking, the end goal of that hearing is what should be the permanency plan moving forward. So the court takes into account to determine that a lot of factors, okay? and you can go to the next slide, Keith. Then you've got the review hearing. Now, in a lot of counties, the permanency hearing and the review hearing are held simultaneously. That is perfectly okay. But you'll also find in a lot of counties, they're broken out. Okay. In a review hearing, statutorily, that's when the court reviews their dispositional order. That order that we just talked about. Remember that disposition slide we just went through that said, these are all the things the court decides. This is the hearing where the court is reviewing that order. So this is a great time for the court. The court's going to be determining, is the treatment plan for the children and the parents still right? Or do we need to amend the treatment plan? Do we need to fix it? Were we missing something that we should have had? Is there something we put on there that we don't really need anymore? Those types of things. Is the placement still in the children's? Is it still meeting the children's needs? What progress have the parents made toward correcting the conditions? Again, that's a behavioral, not just to check the box. Whether or not visitation should be continued or modified between parents and children and between siblings. It's one area where, again, these family time plans are really important for PARB members to understand, because it's also PARB's role as a monitoring agency to kind of hold DHS accountable to ensuring that they're following their own best practices and policies, right? Again, whether or not reasonable efforts are ongoing. And then if a child is 14 years of age or older, if there are independent living services being made. So if a case is only set for review and not for permanency, should you make a recommendation that the permanency plan change from return home to adoption? No. And the reason being is because the judge is not in a position to make that finding at that hearing. Okay. So that's why knowing the type of hearing, knowing what the judge reviews at those hearings is important. And I know that when I say this, you're going to laugh, and that's okay. Laugh. Because it might be the cure for insomnia. I might actually help you out. But go back and read some of these statutes, these key ones that will actually walk you through what the judge does at each hearing. Okay. It will be, you only have to read it once, but I think it will be really mind altering for you to see, hey, this is kind of what we're doing. Okay. Next one, Keith. Okay. Writing the recommendation. So I start with 3 propositions. First, formulate your concern. What are you concerned about? I give this example. The board is concerned that mom is only having 1 hour of visitation per week. Okay. I have spent almost 20 years practicing in front of judges. And I can tell you right now that if you do not support your concerns, they will ignore them. They will. Judges are fact-based. They have to be. They have to rely on more than just gut feelings and crystal balls. They've got to have facts. So a good example, I think, and using the finding box of your report form is where this would go. The board is concerned that natural mother is only having 1 hour of visitation for the following reasons. The child is 1 year old and best practices recommend multiple short weekly visits. Per the DHS worker, the natural mother has made substantial progress on her treatment plan and has demonstrated sobriety for 3 months. So yes, she's checked her boxes, but she's also behaviorally demonstrating sobriety. And both the foster mom and DHS report that mom does very well with the child during visits. Now you can go into more detail if you want, but for purposes of our slides, I kept it pretty simple. Okay. Next slide, please. And then provide a solution, because PARB is more than just pointing out things. It's if your end goal is to provide a solution that makes the experience in foster care better. So again, I repeat this just because it was on the last slide, but we're concerned. We know why we're concerned. Therefore, PARB recommends the family time plan be amended to move to monitored visitation and increase visitation to 3 times a week for 1 hour. Have at least 1 visitation in the natural mother's home to start familiarizing that child with that space. Okay. The more you know, the better your recommendations can be, which is why I know it's boring, but reading policy, reading statute, talking to your local DHS members, not even about a case, but say, reach out if you're in whatever community you're in, reach out to your DHS supervisors and say, hey, are there any big changes that's come down the pike? Is there any big philosophical practices you're making? I really do think like the family time plan is a big one. I think you guys, when you learn more about that, kind of will be shocked. These are simple writing tips. I think they're probably common sense, but remember, you are dealing with judges and they don't like to be told what to do, generally. So be advisory, do not dictate, meaning wrong would be DHS did not make reasonable efforts. Right would be PARB is concerned DHS has not made reasonable efforts. And then why? You have to always give the why. But for purposes of the slide, I cut it there because we run out of room. Be professional. Watch your spelling and your punctuation. Don't restate the history of the case. You don't need to do that. Okay. I promise they've got it. As we've stated, use facts to support your recommendation. Be accurate. Now, I will tell you the worst thing that you can do in one of these reports is put information in there that is not accurate. Okay. If you do, you just lose credibility. Okay. And so if you get information, you're like, I'm not sure that's right. Get to the bottom of it if you can. Use bullet points, numbering, and indentation to make it easier to read. Every judge that I have talked to, and I've talked to about PARB, 4 in Tulsa County and all 5 in Oklahoma County, will tell you that it is helpful for them because they're reading so much, guys. They're reading so much that they want to be able to get to the point as quick as possible, right? So try to structure your reports visually where your recommendations stand out. And I'll show you a good example of that. Okay, Keith, I think next one. These are some writing tips. I think these things are globally super important. First of all, documenting expressed concerns by the parties is okay, especially if those parties do not have a strong role in the proceedings. For example, you're talking to the foster mom, and the foster mom says, hey, I'm super concerned that every time Billy comes back from a visit, he bangs his head on the tile floor. Okay. You don't always have to have a solution to that. You don't always, but you certainly probably want to let people know that's happening, especially if the foster mom isn't coming to hearings or isn't writing court reports or maybe has a tense situation with the DHS worker. So it's okay to say, hey, spoke to foster mom and foster mom noted this behavior is occurring. I would then encourage you to make recommendations to address it, but at the very least, putting that information out there is okay. Little things matter. Big issues, guys, they're going to get addressed. I hate to tell you, I will tell you, I think if PARB could get away from ever touching on the issue of termination, we would go so much further. And let me tell you why. Termination is it is solely dependent upon whether or not the state can meet their burden under the law. That is it. It doesn't matter whether or not you think it's right or wrong. It is a legal determination. And I think that the state of Oklahoma, the child's attorney can file a motion to terminate as well. It's just much more rare. But the state of Oklahoma, I promise you, and I don't mean this bad, but I was the state of Oklahoma for 5 years. They're not going to look at PARB's recommendation about termination and be like, yes. Find a way to express your concerns about maybe the length of time, because that's generally when termination comes into play, when people are concerned that the child's been in custody for so long. Highlight that in a different way. This child has been in custody 160 months. This child has demonstrated problems attaching because of the length of time. All things that go to support termination, but that aren't just ending with termination. Does that make sense? You want to give the state the reasons that they can look at it and be like, okay, I can prove this. Like 160 months, I can prove. You know what I mean? I can prove there's attachment issues. So just food for thought. It is important to know the background of the case, but it's not your role to reinvestigate it. And you really should, if at all possible, understand as much of the dynamics of the family and the decisions made by the court and the agencies, but don't spend your time looking for error or fault. I mean, if you notice fault or error, that's okay. Like, that's a good part. But moving forward, it's how are we going to fix it? That's that. If you keep that in your mind, like, how as a PARB member can I bring a solution to this table? That's kind of where we start making differences. Okay, I think Keith, the next. Oh, my next is the record. Did my recommendation make it on there? Okay, so this I really was I thought an excellent recommendation. She documented her concerns or her conversations with DHS, CASA, and the foster mom, so that the court knew that that was coming, that her information was being validated by those individuals. She kind of gives a little summary of what she understands is going on right now in the case. She reports like natural mother reaches with questions and it is her best experience with bridging. She quoted the foster mom so that the foster mom's thoughts, which were a positive, were brought to the table. She mentions the things she thinks are going really well, that mom's engaging in her ISP. She's committed to building a relationship, but she then mentions her concerns. And it's okay to give both sides of that coin, right? That she's concerned about the length of the case. So then go down, if you will, keep, you don't mind, to the recommendations. See how they're bullet pointed or numbered, and they're broken out. They're very easy for the judge to follow. The judge can look at it and be like, okay, we need to help mom with her drug testing. Let's look at other alternative methods for drug testing because we may not be catching everything in her urine. She recommends unsupervised visits begin and trial reunification begin if she continues to test clean. When they begin, she specifies particular services that might be beneficial. Sooner Cal Healthline, Parent Pro through Health Department, child guidance, and emergency infant services. So she's bringing some providers to the table that, particularly if you've got new workers, a new DA, they may not be aware of. And then in the event that termination occurs at some point, because of the foster mom's relationship with the child and relationship with the family, she recommended foster mom remain the adoptive placement. So bullet point, laying it out, kind of gives you a good summary, something that the judge can, with meat in it, that the judge can look at and be like, oh yeah, okay, I didn't know that, or that's a good recommendation. And I think that wraps me up, unless somebody had questions.
Great job, Kim, as usual. Does anybody have any questions?
I have a question. This is Lucinda, ICWA PARB. So Kim, you had mentioned about, the earlier cases when a child first comes into custody, that, PARB really does not need to review those types of cases. And just, looking at the Indian Child Welfare Act and notification of tribes at the beginning, things like that, would that be a special exception where
Yes.
a PARB? Okay.
Yes.
I didn't know if we
Yes.
should not review those early.
No, I could not agree with you more. The notice issues in ICWA cases, the timeframes in adjudication change for ICWA cases. Particularly, I don't know if you all know this, but if you don't, one massive issue in ICWA cases is that there is in Oklahoma, there is the Federal Indian Child Welfare Act, but then there is the Oklahoma Indian Child Welfare Act. And the Oklahoma Indian Child Welfare Act has a very important provision in it that says a pre-adjudication custody order may not remain in effect for more than 30 days unless the court takes expert witness testimony. And I think you will find, if you are sitting on an ICWA board, Lucinda, that depending on the county, it is rarely followed and is a ground for on 31 days for the parent's attorney to move to invalidate that foster care placement. And so there's lots of little things that ICWA should review early on that you would not necessarily be reviewing in a normal case. So very good point.
Well, and those of you that are meeting Kim for the first time, she is our PARB staff person assigned to Tulsa, but is a practicing children's attorney, court case management for years. I rely on her all the time for helping me understand the legal side of things, and you all need to know that we have her as a resource if you have questions, you know, later on.
Yeah, I'm always happy to help. I've had members from other boards. I think I saw Harvey on here. He's here and we've met, and he's reached out came to a meeting, and I'm always here to help, or staff cases, or if you have a question about a legal, you can text me, you can email me. It's fine.
Yes. And I hope I made it very clear. I know a lot of you are probably thinking right now, I was a little nervous when we were kind of putting this together. It's like, you know, oh my gosh, we review too many cases to look at this level of detail, or we just don't have people with the same kind of knowledge of the child welfare system on our board that maybe someone in an Oklahoma County or Tulsa County board does. That's okay. You know, I mean, you've heard the statement, you know, the kind of joke, how do you eat an elephant? One bite at a time, right? Maybe look at some of these tools, maybe think of these concepts, talk at your next board. You know, hey, I said it on this training, and they talked about maybe we should look at like what particular hearings coming up. So when we look at the docket, let's see if we can figure out what kind of hearing it is, or maybe ask the bailiff if we can't tell which hearings, and maybe we should skip these this time so we can focus more on those cases. Or, you know, maybe we should ask child welfare more about, you know, this particular area next time. Or maybe, you know, instead of doing a group discussion about all the cases, maybe, you know, at the beginning of the meeting, let's all spend 10 minutes reading about the case before we hear from child welfare, or before we have a group discussion. You know, just, I encourage you just to try to find, you know, some of these things that might work, just to try to, you know, again, I think showing up, talking to child welfare, writing recommendations, keeping an eye on these cases, and letting the judge know that you're watching and helping, letting child welfare know that you're watching and helping, in and of itself is helpful. But how can we take our game to the next level? And maybe your game's here and you need to take it here. Maybe it's here, you need to take it here. Maybe it's here, you need to take it here. But hopefully, you know, some of these tools can help you do that, if that makes sense. You know, I always end up waxing philosophical at some point. So that's what I was thinking.